All right.
You get what you pay for, though, right?
We did, yeah. That was a special, so it was cheap. So it was like a $5 haircut. That was right. Well, we are at the financing section. We left off with Yasmin finishing. She actually started this section. This is the start of the 75% slide, so she got you a little ways into this. I just want to kind of recap a couple of the last slides before we get going. 14 and 15 are all financing, and they're financing principles, by the way. My goal for you is to get the principles of these sections. I do not want you to get lost in the arithmetic. We are going to do math. There will be some math on your national section. There will be no math, arithmetic on your state section. You may be asked to do calculations in the national section that are based on the state section. You may be asked concepts about the math. So you need to be prepared for it. However, what I have found is people will spend hours trying to get the math right, and it's like 11 questions out of 112. So I'm glad that you got those right. Those 11 are not going to get you through. So if I had to coach you on this, look at your syllabus and spend the appropriate amount of time on topics. And the state stuff is obviously going to be one of the most important. So as we move through today, and probably the next couple of classes as we get to the finance section, keep it topical. Don't get lost in the math weeds. Understand the concept. We will do the math, and I want to make sure you understand it as we go, because you'll need to know a couple of the formulas and the ability to perform them. And realistically, when you get out of this class, some of the things we're going to learn over the next couple of classes are real practical. You'll need to be able to do that to help your business. So it's not a wasted skill. I want you guys to learn it, hopefully retain it. Some of the stuff we're going to get into is deep lender stuff, but it's important to know how they do their job to help you do yours. Does not mean you will be doing their job. We will always I point to these guys because they used to be lenders. So we don't have to know how to do the lender job, but we need to understand how they do theirs so that we can better coach our clients and get them where they need to go. So with that being said, you guys did go through the objectives. You talked about the mortgage loan being an instrument, the instrument that is securing financing. Remember the difference with the mortgager and the mortgagee? You've got that graph in your book where everybody's the E. This is the weird one. The homeowner is actually the mortgager who is giving the mortgage to the bank. So the bank is the mortgagee. So interest is paid in arrears. All of us at some point have probably rented or paid rent somewhere. You pay rent on the first of the month for the month that you're about to live in it. So this is June. Coming up in July 1st, you will pay July's rent on the 1st. Mortgages are backwards. We call it paid in arrears. So if you're paying your mortgage on July 1st, you're actually having paid for the time you spent there in June. Does that make sense?
Yep.
This is really cool, by the way, because this is why this is relevant. When I work with a buyer client and we close June 30th, we're going to close the last day of June. When is their first mortgage payment going to be due? Not till August 1st, because they get all of July, and then all of July, and then August 1st, they're paying for July in arrears. Does that make sense? So even if I close the June 15th, middle of the month, same scenario. Their first mortgage payment is not going to be due till August 1st. They could have up to 45 days with no mortgage or no payment. Now, that doesn't mean they're not paying it. It's getting collected at the closing table for the prorated part of that, which we will also engage in today in prorating this interest. We're going to talk about prorating interest and how that works. But that's the difference between rent and mortgage payments. They're paid in arrears. We're also going to talk a little bit about this deed of trust and how that works, which, again, this will be a little bit of a recap from last class. So, mortgager and mortgagee, we talked about that. This is title theory state. North Carolina's title theory state. Interestingly enough, South Carolina is a lien theory state, right across the line. So title theory states have a deed of trust, and it's a three-part instrument. So it's a mortgage that has three parts. Okay? It has the buyer, the bank, and a trustee through this deed of trust. It's a three-part. Versus a lien theory that is a two-part between the bank and the borrower. We'll get more into that. I just want you to understand we are title theory lien theory also exists. You'll start to see more of the L's going to T's because a title theory state makes it more convenient for a lender to get their collateral back. What's their collateral?
House.
The house. So in the event of a default, a title theory is easier for a bank to get their mortgage back because in the process of getting a loan with a title theory state, you sign a permission slip that says if I don't pay, you can foreclose on me. What's that permission slip called?
For sale.
Well, it's actually the deed of trust. The deed of trust is much more complicated, but I summarize it essentially as a permission slip that says if you don't pay, you don't stay, and everybody agrees that if you don't pay, you won't stay, and you're giving permission for the bank to come take your house from you. Whereas in a lien theory, the note is recorded, and if you default on the note, they have to take you to court, like any other contract. You're breaching a contract and they take you to court. With a title theory, there's no court foreclosure required. It's called a non-judicial foreclosure.
What you got off the coast of Florida?
I'm going to go with
Virgin Islands?
Yeah, probably.
probably U.S. Virgin Islands.
Yes, has to be.
Yeah.
Yeah.
Interesting enough, you know Bermuda's like right there?
I always thought it was like further down.
I looked at it, it's
Yeah,
almost
pretty
directly
straight
out
across, yeah.
from Myrtle Beach. I always thought it was down here because I think Caribbean, but it is almost directly east of us.
I always thought it was south too.
Yeah,
No.
it's not. It's just a little tiny dot right out here. I looked at sailing there. I thought it'd be fun. Like, although if you miss it, you're screwed because you're in England.
In like 6 hours.
Like, whoops. All right, so the deed of trust is again a title theory state product, and that's what we have here in North Carolina. And this is actually, I think, where we left off, correct? So now we're actually officially picking up the new material. Any questions before we continue our trend or conversation on this? So this is a good or a better visualization of the title theory versus lien theory. So with a title theory state, when you purchase a property, you are going to sign the mortgage and a deed of trust. So the borrower, who is the trustor, will retain equitable title. The lender is the beneficiary, and then they have a trustee, and this trustee holds the legal title. So this deed of trust gives the trustee permission to sell it, the power of sale, it comes built in with the power of sale clause, to foreclose and sell it in the event the borrower defaults. The reason they're the trustee is because they are essentially a neutral third party. They don't really work for the bank, they don't really work for the borrower, they just keep everything nice and fair until there's a problem. And the problem arises if there's a default, meaning someone's not paying their mortgage, at which time the trustee has the ability to, built into the deed of trust, to foreclose. And then any proceeds received from this foreclosure sale goes to the beneficiary, i.e. the lender.
Who are these trustees? Like if you went to BB&T and got a loan, who would the trustee be?
They're just attorneys. She asked, who's the trustee? There are specific attorneys that focus, and this is a business practice for them. Brock and Scott is one here locally that does a whole lot of these. I know that because during the foreclosure boom, we always went to Brock and Scott's website because they had to post it, and that's where we would go look for the upcoming foreclosures because they would post it as the trustee. This is a trustee sale that's coming up.
Who chooses them? The borrower or the lender?
I suspect the lender does. I actually don't know the answer. Your question was who chooses the trustee? Is it the lender?
It
the
is.
lender.
A lot of them, it's the regional managers of the bank, but then they can assign the trustees out later.
Yeah,
To your point, the
and if
attorneys
they
to do the real work.
Yeah, and if they get too many, they probably have multiple trustees. Yeah. So that's our title theory. Now, once we pay it off in the title theory state, so this is the ultimate goal, right? Live there for hopefully 30 years, pay it all off. You no longer have a mortgage payment. Yay, this is great. So upon payoff, final payment gets made to the lender. The trustee will then record a deed of satisfaction. And that deed of satisfaction says our debt has been satisfied, and therefore the deed of reconveyance can be filed, returning full title to the borrower. So the legal title combined with the equitable title would return full legal title to the owner. Meaning they own it in severalty, it's unencumbered, they have all legal rights to the property, no one else has an interest in it. This is a three-party instrument. Questions on title theory? Feel good about that? Now here's, yeah, go ahead.
Now, just the three parties are the borrower, the bank,
Yep.
and the trustee is the extra thing, and the trustee is the extra thing that we have in the title state.
You got it. Yep, the trustee is that extra third party that we have in a title theory state. Yep. And the interesting part of this, and I told you before, and it comes relevant now, we have a saying in real estate, right? One to buy, two to sell, right? Have you heard me say that before?
Yeah.
So it's one to buy cash. Because if you're getting a loan in a title theory state, this deed of trust, I told you, has that power of sale clause built into it. Meaning this attorney or this trustee can foreclose. If a husband and wife are going to own this property, we know that they have interest in the property through tenants in the entirety, right? So one person, one buyer, could buy it, could qualify for the mortgage and get this loan. However, the bank is going to require both spouses to sign this deed of trust, given permission to the trustee to foreclose if necessary. Otherwise, and this actually happened a lot during our foreclosure botch, we had deeds of trust not signed by everyone, and wrongful foreclosures took place. Because someone who had an interest in the property did not sign permission slip to foreclose,
Wow.
but trustee foreclosed anyway. So therefore you have a wrongful foreclosure, that just created all kind of mess.
Wow.
So one to buy cash, two to buy with a mortgage, and always two to sell if we have married folks. Questions on that?
I guess you could run into that when a person bought a house and they got married later and they kept the same house.
You can run into it a lot of different ways, yeah, because sometimes it's they got married after, sometimes it was married before, sometimes it depends on how they took title. Because you can, in fact, be married, by the way, and take ownership as tenants in common. You just have to specify at the closing, we do not want tenants in the entirety. We want tenants in common.
But you have to
Even
give
if
it
you're
away.
married?
Even if you're married. You can take title however you want, but if you are married, without any alterations, they will give you a tenants in the entirety. You can specify how you want to own title. So long as the lender's okay with it, it's okay.
It's like a mortgage prenup.
Yeah, it's like a
Yeah,
mortgage prenup.
exactly
Exactly
what it
right. Exactly. Good way to put it. Like a mortgage prenup. All right, so also make sure you know this deed of reconveyance, and that's how the full rights get reconveyed back to the
That's
original
after
owner.
you pay it off.
Yep, this is after you pay it off.
And they're really recording those?
They should. Sometimes this is called a deed of satisfaction.
Yeah,
Well,
okay.
Yeah.
typically it's a deed of
So by
satisfaction.
operation, when you satisfy, it defers back.
Correctly.
It's
Usually
not
they
really a
have both.
separate instrument.
It can be, but usually here when it's paid for, it's a deed of satisfaction, and then they should file a deed of reconveyance, but most of the time it's built in, it's one. Yeah, so deed of satisfaction reconveys full title.
Wow, okay.
Yeah, so that's the title. Deed of trust secures the promissory note to the house. It also has this hypothecation. Yeah, big words. Big words today. So hypothecation is simply defined, means to pledge a property as collateral for without giving up possession. So you're hypothecating the interest of the property to the bank, but you get to keep it and use it as if it's yours. So you always retain possession. Because if you think about it, do we really own our house?
Not until we pay for it.
Not until we pay for it, right? So you have hypothecated your house until you own it. So defeance clause, this is another, just a couple of definitions with clauses that you'll run into in the title theory or any theory. But defeance clause is if a borrower repays the loan in full, the trustee will return the rights conveyed. So any interest that the lender has given will reconvey. This is that power of sale clause, and where do we see it at? Deed of trust. This is going to be built into that deed of trust. That's important to know. It says if you pay, you stay. If you don't, you're going to go to foreclosure. Remember, power of sale clause is in the deed of trust. Equitable title. The borrower has the right to use and possess the property as if he or she owns it. So you have equitable title. The demand for the return of legal title when the debt is paid off, that's the reconveyance. get the rights reconveyed. And then you have full title once you've paid for it. All rights thereunto. No one else has encumbered it. No one has any interest in the property other than you. You own it outright. Which is great because you can do fun things with it. Questions on that?
What if they repossess it and they sell it for more than what the person bought it for?
Ooh, that's a great question.
The trust keep them.
So, two-part answer. Her question was, what if they foreclose and they end up selling it and making more money than they were owed? So, one, I don't think it's ever happened because I'm pretty sure there's a fee for that. And two, the answer is they would have to give it to the borrower.
I mean, I was thinking in terms of improvements.
Um,
You know, if they had spent all their money on improvements and then they had a bad turn, you know?
oh, right. So, if from a financing perspective, if you owe the bank $100 and they foreclose on it and they sold it for $125,000, then if the 100 satisfies them, then legally they should return to you the 25,000. To my knowledge, that's never happened because I'm pretty sure there's a shipping and handling fee for that that would always eat up any proceeds.
Wow, really?
Yeah, they fee you to death. Yeah.
Yeah, I would just ask Mike, like, let's say like you're on your last couple of years of paying off your house and, you know, all of a sudden you lose your job after 25 years of paying your house. Like, when they say, let's say you only hold $20,000, $15,000 left, what do they do, like, when they sell your house? Do you get, you don't get that money back, or that's just
Well,
the equity that you have in it?
ideally, like we just talked about, if there is that much equity in it, then you should get it. Hopefully, though, you've called me and I'm like, let me sell this house for $50,000 today to an investor who's going to pay you $50,000 today to satisfy your note to keep you out of foreclosure, who then gets a good deal on a property that they can make money on. That's usually how that works.
Okay.
Because by the time if you've got that much equity, I don't understand. It happens, but and this is frankly the We Buy Ugly Houses model. They find people who have equity in their house
You're desperate.
that have now come to a point of desperation or near foreclosure, and they say, we don't care. We don't care that you have 14 cats. We're going to buy your the house the way it is. Cats can come included. Don't mind.
We don't care if you smoke a million.
They don't care if you smoke. They don't care what it is because there's equity in the house. Anytime you have equity in a house, an investor will buy it. The end. Somebody will buy it. Doesn't matter how bad it is. Someone will buy it. And that's their model, is they will shotgun hundreds of offers, but one or two of them are going to come back with, yes, please take this off my hands to absolve me of that debt so I don't have to worry about foreclosure. And they walk away and go rent something nice and neat, and the investor gets a good investment.
This is an off subject, but it made me think of it. Is it possible to, when you're doing advertising, to advertise that the last owners didn't smoke?
You can say that. Yeah, smoking's not a protected class. You could say never been smoked in. I wouldn't say that it has been
If you knew
smoked
for
in.
sure.
Yeah, I probably would be careful with representing it just because of, like I said, had to notice fact.
Oh, yeah, because they could have friends over.
Especially if I sell it to someone who's highly allergic to smoke and they come in and they have a reaction and I misrepresented it. I would always be cautious unless the seller represents it. Then I can convey their representation and not mine. But yeah, I'd be cautious with that. But there's nothing wrong with it. Say the current owners have never smoked in the house. If they state that, I can restate that and take it.
Like you said, the current owners are not smokers.
Yeah, I can definitely say that. Current owners are non-smokers.
Yeah, that's good. That's a better way to put it.
So, lien theory is what we're going to talk about when you get back, because it's time for your first break.